Time is 1:31, and I'm going to call this meeting of the House Labor and Industry Committee to order. We had the pledge this morning that will serve as a pledge for this afternoon session as well. And I'd like to welcome all to this afternoon committee meeting. Of course, the meeting is being recorded as was this morning, so please silence your devices as you can to minimize interruptions. And I'm going to ask the secretary if she would please call the roll for this afternoon's meeting. Present.
Deluger. Here. Josh.
Here.
Keller.
Here.
Plonk. Here. McKenzie. Leave. Maloney.
Here.
McGinnis. Leave. Spencer. Leave. Nelson. Rader.
Here.
Topper.
Here.
Chairman Galloway. Cephas. Sorry, did you say leave? Deasy. Donatucci. Here. Kruger Brannicky. Here. McNeil. Here. Miller. Mullery. Leave. Nielsen.
Here.
Ravenstall. Leave. Snyder. Here.
Thank you very much. Today we will be discussing House Bill 2571, and this is a legislative proposal by Representative Klunk, which would bring Pennsylvania into compliance with the U.S. Supreme Court's ruling in Janus versus AFSCME. Representative Klunk is obviously a member of this committee, so first, before we begin with our first panel, I'd like to recognize Representative Klunk to make some brief remarks and give any background she would like regarding her legislation. Representative Klunk?
Sure. Thank you, Mr. Chairman, for the opportunity to discuss with you in the committee my legislation, House Bill 2571. As you all know, the United States Supreme Court issued its decision in Janus versus AFSCME that government employees who have opted out of their unions should not be forced to pay union agency fees or fair share fees. And this ruling does not apply to private sector unions and employees. Janus is certainly a very important First Amendment victory for all government employees throughout the Commonwealth. This ruling helps to ensure that these vital employees have a choice to support unions that may not hold their own personal political beliefs. Specifically, the Supreme Court ruled that taking money from workers who did not affirmatively consent to fund this political activity violates their constitutional rights. Unions spend big money on political activity, and these fair share employees contribute quite a bit to this activity. And now political activity isn't just campaigns. Janus did hold that it's union activity, including wage, pension benefit, anything that is part of those contract negotiations. $114 million has been spent by public sector unions on politics over the last 10 years. These are the very unions who have opposed reforms of our woefully underfunded pension system. These are the very same unions who have worked to block popular changes to our state-owned liquor stores. And these are the very same unions who have stood in the way of job-promoting regulatory changes, often over the objection of government workers themselves. 28,000 Pennsylvanians who are workers here in the state pay fair share fees. Fair share costs these employees a collective $9.7 million just in 1 year. And that equals just shy of $350 per worker per year. My legislation, House Bill 2571, simply ensures that the law of the land is enforced here in Pennsylvania and that these government employees are made aware of their rights. Ultimately, House Bill 2571 is a consumer worker protection issue. House Bill 2571 would further protect the rights of individuals in a collective bargaining unit who are not members of the representative union, also known as those fair share payers. Specifically, the legislation proposes the following 4 changes to Act 195. First, it directs public sector unions to inform non-union members of the Janus decision and that these once required fair share fees to the union are now purely voluntary. These workers will also be informed that their employment status will not be affected if they do or do not decide to contribute on their own accord to the union. Second, the bill requires a public employer to notify job applicants that being a member of the representative union is not a condition of employment, and that as a non-member, they have no obligation to make any payments to the representative union. Third, the bill prohibits public employers from making any payroll deductions from wages of non-members and requires employees to make voluntary payments directly to that representative union. And this helps to ensure that those payments are purely voluntary and consented to by the employee. Finally, the bill repeals 2 Pennsylvania laws that authorized the payment of these fair share fees by non-members, Act 84 of 1988 and Act 15 of 1993. This will help to ensure that Pennsylvania law complies with the Janus decision and takes these unconstitutional laws off the books. House Bill 2571 represents a huge opportunity for us to expand worker freedom here in Pennsylvania, to protect our workers and their rights, and to foster fairness in our political system. Again, this is ultimately a consumer worker rights protection bill. Mr. Chairman, I thank you and the committee for their time, and I look forward to hearing from our testifiers.
Thank you, Representative Klunk. Now we are going to move into the first panel discussion. For that first panel, we have David Osborne, attorney with the Fairness Center, Keith Williams with Americans for Fair Treatment, and Beth Ann Mumford of Americans for Prosperity. Just want to remind our panelists, if you could summarize your testimony and keep it to about 5 minutes, and our research analyst, Shannon Walker, on the end of your table will give you the signal. So that is your signal, and you may begin, and then we'll open up to questions after you're done. David, if you want to begin.
Sure. Good afternoon. Thanks to Chairman Kaufman and Galloway, Representative Klunk, and to the rest of the House Labor and Industry Committee for your attention to this issue. My name is David Osborne. I'm President and General Counsel of the Fairness Center, a public interest law firm that protects those who are hurt by public sector union officials. The Fairness Center represents various public sector employees, some of whom are members, some of whom are non-members, who would be impacted by this or other bills that have been introduced. I am here to represent those clients today. On June 27th, the United States Supreme Court decided a case called Janus versus AFSCME, Council 31, involving a public employee from Illinois named Mark Janus. Mark Janus claimed that Illinois law unconstitutionally permitted his Illinois union to extract agency or fair share fees as a condition of public employment. He argued that it was a violation of his First Amendment rights to be forced to subsidize the political speech of a private organization, particularly when he disagreed with that private organization. The Supreme Court in Janus decided in Mr. Janus's favor, holding that agency fees authorized by Illinois law violated the First Amendment. As Justice Samuel Alito wrote in the majority opinion, the idea of public sector unionization and agency fees would astound those who framed and ratified the Bill of Rights. In reaching this conclusion, the Supreme Court overturned its own precedent dating back to 1977, under which it had tried to draw a distinction between union political activities and core representation activities. Over the decades, that distinction proved arbitrary and unworkable for one simple reason. Everything public sector unions do is political. The Supreme Court also addressed a question that Mark Janus did not actually ask, whether unions could nevertheless charge agency fees with non-member employees' affirmative consent. And the answer to that question, according to the Supreme Court, is yes, provided the union secures a truly voluntary waiver of an employee's right not to pay agency fees or some other payment, it can continue to deduct those fees or payments going forward. I advocate on behalf of my clients for 3 basic changes to Pennsylvania law in light of the Supreme Court's decision in Janus. First, it is essential that Pennsylvania bring itself into alignment with Janus by repealing its fair share fee laws. Pennsylvania's public sector employees should have the right to stop paying their unions and can justifiably expect that their unions will honor that right, but it is not automatic. 8 of the Fairness Center's clients have pending cases that were affected by Janus, but the courts have yet to rule on how Janus impacts Pennsylvania law. Janus addressed the issue generally and Illinois law specifically, but Pennsylvania's fair share fee laws are still on the books. That is not just a technical point. Our fair share fee laws may be used against public employees unless the General Assembly repeals those laws. House Bill 2571 does that. Second, the General Assembly should proactively oversee the union's efforts to secure non-member fees going forward. Again, Janus ruled that extraction of agency fees as a condition of employment is unconstitutional, but it does allow public sector unions to take fees from non-members as long as they give affirmative voluntary consent. For the moment, the process of obtaining such consent is completely unregulated. That raises a number of questions. For example, what form can a request for consent take? And at what times can such requests be made? The bill under consideration today at least begins to address these issues by ending payroll deductions and requiring a notice to non-members and new hires of their rights under Janus. Thirdly and finally, the General Assembly should repeal its maintenance of membership law. Pennsylvania's maintenance of membership law purports to keep public employees from exercising their rights by limiting their opportunity to leave a union and limit that to a 14-day period prior to the expiration of a collective bargaining agreement, which may span several years. The bill under consideration today does not address maintenance of membership, but I believe other bills will. For those on the committee who did not celebrate Janus, I think these measures are still worthy of your support. Pennsylvania has an opportunity to implement Janus in a way that will serve and preserve the rights of public employees at every level of government. For those who celebrated the Janus ruling, I just want to emphasize on behalf of my clients that implementing that ruling here in Pennsylvania is not automatic. Public employees are counting on their legislators. Thank you. I'd be happy to address any questions you may have.
And Keith, you may go next. We'll do questions at the end of the panel.
All right, sounds good. All right, so thank you, Chairman Kaufman and Galloway, Representative Klunk, and to the rest of the House Labor and Industry Committee for the opportunity to testify today on behalf of HB 2571. My name is Keith Williams, and I am the Director of Outreach at Americans for Fair Treatment, an organization dedicated to public sector employee advocacy. For the past 21 years, I've actually been a public school teacher. So you heard from an attorney, I'm going to bring it down a little bit. 18 of these years were spent at New Oxford High School, where I taught several English classes, including a Middle States accredited course that took students to places like Yellowstone, the Grand Tetons, Grand Canyon, Zion, Redwoods National Park. I've sacrificially served both my school and my community as a track and cross country coach, and through over a decade of volunteerism in search and rescue. In my new role as Pennsylvania Director at Americans for Fair Treatment, I am a passionate advocate for the rights of public sector workers, particularly our public school teachers. And that's because I've been a teacher, a coach, and a volunteer for the overwhelming majority of my professional career. When it comes to unions, I am here to testify as a public sector employee for over 2 decades. Believe me when I tell you that I understand how union membership works at the ground level more than anyone else you'll hear here today. In addition to my testimony, you'll also hear from organizations and unions that they support. Perhaps there are even some individuals here today who owe their elected positions to public sector unions. What you most certainly will not hear is testimony from a public sector employee who thinks that being kept in the dark about his or her rights is a fantastic idea. And to that, I would point to Representative Klunk's comment about HB 2571 and why it's necessary. This really is a consumer protection issue. People simply have the right to know what their rights are. It's necessary because I know from personal experience as a public sector employee that unions cannot be trusted to hold themselves accountable. After a few years of short and long-term substitute positions, I entered the classroom as a full-time teacher in August of 2000. And like any new teacher, I was assigned a mentor who offered guidance and support as I navigated those anxiety-ridden first few weeks of school. And I endured those absolutely delightful state-mandated induction meetings. On that first school in-service day, my mentor pulled me aside. She warned me that as a young man and a coach, I needed to be particularly concerned about protecting my job. The questions began. What if a student makes a false accusation? What if something happens at practice? The what if questions continued as I was led to the PSEA registration table, where I was sold on the idea that I needed liability insurance. So begrudgingly, I became a union member in that first year of teaching and a de facto donor to the Democratic Party under the promise of protection. I joined because I was led to believe that it's just part of becoming a teacher. I was never told otherwise, and my mentor led me to believe that as a professional, joining a labor union was just some reality of public sector employment, that all teachers did it. Obviously, overtly forcing an employee to join a public sector union as a condition of employment is both illegal and a gross overreach of a political lobbying group. Public sector unions are clearly aware of this fact. However, the reality is that employees across the Commonwealth are led to believe that they must join a union as a condition of employment every single day. In my experience, and that of most employees across the Commonwealth, the union paperwork is subtly included with our health insurance and other new employee induction paperwork. Membership is assumed, and the option of not joining is never mentioned. As little as 4 months ago, non-members were still forced to become agency fee payers, which many workers chose in an attempt to avoid supporting union political activity. Now, after the U.S. Supreme Court decision in Janus v. AFSCME, it is even more important that employees understand that they are no longer forced to pay a union in order to keep their jobs. In my experience, unions are usually smart enough to fly under the radar and only verbally imply that membership is a requirement. Some unions, however, are not so smart or so subtle. Some of these unions are willing to deceive employees through overt lies to gain members, and in some cases will go so far as to state in writing that union membership is actually a condition of employment. We are here today, and this bill exists because public sector unions and their political benefactors clearly understand that they can create and maintain a revenue stream by keeping employees in the dark about their options. House Bill 2571 protects public sector employees, employers, and taxpayers from the deception and the manipulation that unions practice in securing their income stream. That public sector union representatives would show up today and have the temerity to openly oppose a bill that ensures that employees know their rights is an indictment of unions' true intentions. People have a right to know their options. HB 2571 helps to ensure that that happens. Thank you for your time today and for the opportunity to speak on behalf of my fellow public sector employees across the Commonwealth.
Thank you. Thank you, members of the committee, Chairman Kaufman, Chairman Galloway, Representative Klunk, for introducing this bill. I'm Beth Ann Mumford. I'm State Director of Americans for Prosperity, Pennsylvania. We're a grassroots organization that aims to recruit, educate, and mobilize citizens to fight for the ideals and values of a free society at the local, state, and federal level. Our grassroots volunteers advocate for policies that break down barriers and enable people to work hard, provide for their families, and achieve the American dream. I appreciate the opportunity to participate here today and express my support for this legislation, HB 2571. An important part of our mission to break down barriers that stand in the way of people realizing their full potential is identifying and championing policies that expand worker freedom and protect employee rights. Specifically, exactly what this bill does in aiming to protect the rights of employees in a collective bargaining unit who are not members of a representative union. HB 2571, made possible directly by the Janus decision, is an important step in the right direction toward worker freedom and the defense of employee rights. In states that have passed similar right-to-work type legislation long before the Janus decision, the evidence is clear that such policies provide not only better overall individual rights for public workers, but also better laws governing measures that affect taxpayers and state and local budgets. According to a recent report released by the Commonwealth Foundation that measured the impact of a variety of union-related state laws and regulations, Pennsylvania was given a D letter grade for its required collective bargaining, binding arbitration during contract negotiations, and forced unionization. These policies actively limit workers' rights. By contrast, neighboring West Virginia, which recently passed its own public sector labor reforms, received a letter grade of B. Looking at government sector union membership across the United States, it's clear that the Janus decision could lead to a large number of Pennsylvania public employees wishing to exercise their constitutionally protected right to serve the public without joining a union. 2017 data shows that the public sector union membership rate in right-to-work states is less than half of the membership rate of non-right-to-work states. Recent data indicates, for instance, that although only 44% of teachers reside in non-right-to-work states, 69% of the membership of the National Education Association resides in those same non-right-to-work states. In the 3 states that recently added a right-to-work status for teachers, Wisconsin in 2010, Indiana in 2011, and Michigan in 2012, NEA membership has decreased 59%, 18%, and 17% respectively. While Janus only applies to government employees in Pennsylvania, other states with full right-to-work laws have enjoyed positive economic outcomes that are worth noting. According to the Wisconsin Policy Research Institute, the presence of right-to-work added an average of about 6 percentage points to the state's annual growth rate between 1983 to 2013. Specifically, between 1970 and 2013, the 22 states with right-to-work laws experienced income growth rates nearly twice as large as non-right-to-work jurisdictions. In other words, those 22 states produced 28.75% of America's personal income in 1970, but over 8 percentage points more, 37.32%, in 2013. Since 1990, in fact, the job growth in right-to-work states is up 47% versus just 21% in non-right-to-work states. Looking at 2 states that recently became right-to-work since 2012, Indiana's payrolls have grown by 5.7%, and in Michigan, they've grown by 4.5%. The data's strong. Policies that enhance worker freedom help to strengthen a state's economy. Now that Janus has restored the constitutional rights of workers, it's time for Pennsylvania to begin dismantling the barriers placed before its public employees. Their rights against forced speech and association, being just as valid as any other employee's rights, would at long last be codified by the legislation before this committee. HB 2571 promotes the values that Americans for Prosperity and its members, specifically that each of us deserves the opportunity to freely pursue our own interests. As such, we're proud to support this bill, and thank you for your time and the opportunity to speak on this afternoon. I look forward to addressing any questions or comments. Thank you.
First, I'm going to recognize Chairman Galloway.
Thank you. Thank you, Mr. Chairman. Thank you for being here. Just give me 1 second. There was a lot of talk in the beginning of this. And to be honest with you, I understand the Supreme Court decision. I get it. As long as people understand that the benefits, one of the reasons why you have members and people that you had spoken about, one of the reasons why they enjoy doing what they do is because of the collective bargaining and the work done by those very same distrustful, what was the word? Deceptive. What were the words you used?
Deceptive and manipulative.
Deceptive and manipulative unions. Mr. Williams, is your organization actively encouraging members to drop out of their union?
We are not. Our primary focus is simply on basically what Representative Klunk's bill does today at a state level. We are informing people of their rights, and we are protecting people when they seek to get out of a union and receive pushback or intimidation or workplace humiliation. That is our focus.
So when you say you support HB 2571, you support the notification procedures, processes and procedures. You're aware that there's going to be notification literally every payday of an employee's right to not join a union.
Yes.
Do you know how much those things are going to cost? How are we going to notify employees of these rights?
That would simply be as I envision it, it could be a line item on the.
Is it going to cost anything? You don't know. That's good.
It won't cost. I mean, it's the cost of ink on a piece of paper.
Do you believe, for example, you just want to notify the employees of this particular right? You don't want to educate them on all their rights, right? You don't want to educate them on the right that they have a right to actually join the union and the benefits of that union. You just want to notify them of their right to not join the union and benefit from the collective bargaining of that union and not pay for it. That's what you want to advocate for. That's what you want to educate them, right? You don't want to educate them on everything, right?
Our focus is to educate people about their rights to join
all
the
the
union,
rights.
their
So you
rights
would be
not to join.
in favor of them being notified of all the rights.
Absolutely. I think everyone should have a right to know all their rights.
So you would be in favor of amending this legislation to include all the workers' rights, including their right to actually join a union and educate them on the benefits of collective bargaining and being part of that union.
If we're going to
Leaving out the deceptive and the manipulative rhetoric, right?
if we're going to get off into the weeds of
No, I'm not getting off in the weeds. This is, you want to notify non-members of their right to not join a union.
Right.
The
But
question
you're-
is, do you want to notify them
think
of their
they
right
are-
to join that
Chairman
union?
Galloway, I think they already have that right. I think that's what
They already have the right, but they're not, you're not.
They actually have union reps sitting in the room with them when employees are hired. They actually have a union rep with them. So I think that's not anymore maybe, but that's where we were. So you're going off in the weeds.
I'm not going off in the weed. This is the bill. HB 27.
Would you like to ask a question or badger the witness? I mean, you just ask a question. At some point, we have to get to the end of your rantings.
If your question is simply, do people have
I'll
the
be
right
honest
to
with
know?
you. To characterize what I just said as rantings after what we just heard for a half hour is ridiculous. I got to be honest with you. What was ranting about what I just said?
Do you have a question?
I did have a question.
Okay, then
Did
ask
he
the question
support-
and let him answer it.
Do you support notification, taxpayer-paid notification of all employees' rights, including the right to join a union and the benefits, therefore?
I absolutely support the right of employees to know all of their rights.
Thank you.
Absolutely.
Thank you. Representative Nielsen.
Thank you, Chairman. I have to put a disclosure. I've been a member of the IBW for 35 years. Proud. I know what this decision does to people. I know what it does to individuals. And I just, the National Labor Relations Board covers a lot of this stuff that makes certain union and non-union members are both, all the rights of workers are protected, and they all have a right to join or not to join. However, today your testimony here has been focused on not to join. And I think that's what Chairman Galloway was saying. You know, we're saying, we want to tell them, hey, you don't have to join, you don't have to join. Me as a member, or you as a member, you are a member. Do you think it's fair to you for the person next to you to pay union dues, to pay the salaries of the people negotiating your wages? Don't you think people should all burden that share? I mean, everybody should pay a little something because you're going to benefit from it. You're going to benefit from that holiday. You're going to benefit from that increase in wages. I mean, Representative Klunk pointed out that, 28,000 employees, okay? How could you negotiate with each one of those employees? I mean, there's not enough time in a lifetime to negotiate the salary of each one of those employees. So don't you think everybody who's part of that unit should pay a fair share to help burden that cost? Or should I, as the union person, say, hey, don't worry about it. You don't have to pay a thing. You know what? I'll put all my money in so you can get a raise. I mean, where's the balance at?
One of the benefits, as I always explained it to people, one of the benefits of teaching, one of the great things about teaching was I could look at my pay scale and I could say, okay, with this many years of teaching and this many credits, I'm going to make this much.
Well, as a teacher, looking at that pay scale,
Right.
okay, you knew that, for 100 years, that union negotiated on your behalf,
Yep.
fought for you to get your summers off paid and all that stuff. Okay.
So that was the benefit, right? Mm-hmm. But then I could turn around and I say one of the frustrations about it is that I know with this many years of teaching and this many credits, no matter how hard I work, I'm only going to make this much. And I understand what you're saying, and that's again, I've heard that argument a lot.
I'm not arguing. I mean, it's just a fact.
I understand the
so,
frustration,
so,
but you also have to consider, and we haven't used the term there yet, but the free rider argument. I would counter. It's a forced rider situation. I certainly did not ask for that representation. I
So
think
should you-
in the case of my school district, we had over 40 teachers who were not union members, who were at one point when the union elected to go fair share for 2 years, forced them to pay fair share fees, and once they realized that they were compelling 25% of the faculty to support political causes that they didn't necessarily agree with.
I'll
back
touch on the
it.
political causes because I was the treasurer and the political director of my particular union. And as a right, okay, they all sign COPE cards according to the federal government, and we have to sign a card that we contribute. You have the ability to ask for that money back, and we have members that always, every year, ask for that money back because they wanted to make certain they know exactly where their donation is. Say when I was running for office for the first time, they wanted to make certain that all their contributions to that political education fund went to me and not to anybody else because they knew me. They felt invested in it. But they had that right under the federal law. I mean, that's already federal law. You can request it. I mean, and under federal law, just like I said, I was treasurer, okay? There's not a nickel, a penny spent within that union that isn't approved by the members. So now, as a former member or whatever, how many meetings did you go to? Because I went to 4 meetings a month. I mean, that was me.
Right.
But I voted on every penny spent in that union. Has to be approved by the membership. I mean, it's clear as day. So if you don't take an active role at your union and you decide not to go, I mean, is that their fault or yours?
If you don't agree with what the NRA stands for, should you join the NRA and have a say in the vote?
They already have that option not to become. I mean, what we're trying to do is we're trying to legislate. I mean, I heard it through testimony that, a right to work. You have the right to organize. Chairman, I'm going to make sure I get the questions in too, because I know you're going to correct me. And if all three of these can address it, maybe all three of these come up. One question to all three, and then I'll be done, Chairman. Do you believe in the right to organize?
Absolutely.
Yes.
Yes.
You talk about representing people.
I thought you were that was your question, wasn't it?
That was one.
I thought you
didn't
said
say
you
I
had a question for all three of
We
them.
got a lot
Okay,
of time
you got
left,
another one
Chairman.
now? Okay, go
Chairman,
for it.
we got a lot
Go
of
for
time
number
left.
2 now.
I got pages and pages of questions, Chairman. I'm sorry.
Oh, I'm sure you do.
I'm sorry, Chairman. You say you represent a lot of people, and you do it out of the goodness of your heart, you know? And I thank you for that. How many cases did you have last year? Representing members that their union rights were.
Yeah, we're talking in any given year, something like 10, 12 cases.
10
Among the-
cases a month?
No,
Okay.
in the year.
A year.
Among 3 attorneys. Yep.
3 is. So you have 3 cases a year, 12 out of 25,000?
Well,
Are you going
No,
to
the number's
evaluate the business
28,000.
model now?
Do you notify them or something? Do you notify everybody that you're there? I mean, how do you do that? Because, I mean, if I needed help, I want to come see you. I want to point somebody over to you. Say, look, you have an employment problem. Go see this guy. I'm going to have him call you. I can't wait till next week. But how do you notify them that you're there?
you know, one of the principal things that we do when we represent a client is we represent them in the court of public opinion. People hear about us because we're doing work for other people.
Last question.
You know,
All three-
I'm surprised. A lot of times people come to us because they thought they were the only person out there who was having trouble with the unions. And as it turns out, we're litigating the exact same case.
But that's all you do is go after unions, right?
No, we represent public employees when they experience problems with their public sector union officials.
All right, so you just go against the unions. You litigate against the unions, right? That's it. That's your
Look at
sole
our-
practice. I didn't have homework because the testimony wasn't given to us prior. Or would it? Okay, that's why I'm.
Look at our
trying to
cases. I
read
mean,
it.
in many instances, what we have to do is
Okay, move on to number
Include-
3. The third question. Keep
All right,
this moving.
All right. Who funds you? That would be all to all three is who funds you? How do you get your funding?
I'll take that. For us, it's basically business owners, private donations from people who agree with simple principles of worker freedom.
And so we're a nonprofit. We don't take fees from our clients in order to do the work. Instead, like any other nonprofit, we have to raise our money.
Yeah, same for us. We're funded through voluntary contributions.
All right. Moving on. Representative Dush.
Thank you, Chairman. I'd like a quick opportunity to answer a couple of questions. The question to Keith about education of the benefits of unionization versus a simple line that says you have the right not to unionize. I would have no, or be a member of the union. I would have no problem with or join as you so wish. But the minority chairman went longer than that and beyond that and saying, expand on the so-called benefits of the union. So I would be adamantly opposed to doing that. They're already doing it. My experience, and I'm sure Wayne's as well, is that in the workplace, the union's doing it every day. And they're talking to non-members and trying to convince them to become members and putting pressure on in some cases. So, yeah, that is something that actually gets done and happens. Is that your experience?
In most cases, unions already enjoy special privileges within the workplace. I can speak to, in our own school district, they have the privilege of using the school internet for union activity. They've got several locations where they can post union information on bulletin boards in faculty accessible areas. Again, that's again very one-sided. That is advertising the benefits. Basically what we're looking for is just simply informing people that it's very straightforward, that you have a right to join, you have a right not to join, and leaving it at that. So.
And just one other point of clarification. When the point was made that you were benefiting from 100 years of somebody negotiating ahead of you, the problem with that is I think right now there might be 1 or 2 teachers in the entire Commonwealth of Pennsylvania that have actually voted to select who they wanted to represent themselves. And without having the ability to, the decertification process, I've lived through it twice with AFSCME, and it's a very daunting task. So the numbers from Wisconsin speak for themselves. 59% of the NEA members walked when they were given the opportunity. There's something wrong with their representation, and I'll use that in quotes, when 59%, well over half of members decide to turn around and walk when given the first opportunity. Thank you.
Thank you. Moving on, Representative Kiefer.
Sorry. Thank you, Chairman. I have a question. Having a spouse that was a longtime member of the union, I certainly see the value of them, and in his profession, I don't know why anybody wouldn't join the union, but I think that they demonstrate that case well. I've gotten calls from my office, though, regarding how to the opt-in and the opt-out time frame, as well as the process to do that has not been as simple as one would think it would be. And I'm all for let's give everybody their information. So you have the right to opt in or opt out, and these are the recourses for that. So I'm not sure what the big deal is with Representative Klunk's legislation that demonstrates that. So what is this a founded issue, do you believe, as far as opting in and opting out and what that procedure is? Does that need to be better defined?
Yeah, and David, maybe you can speak to this a little bit too. I can speak, again, from the classroom side of it, boots on the ground type of thing. The maintenance of membership certainly creates an issue. We have, again, I'll speak to school districts. We have 500 school districts in Pennsylvania. It's, in theory, you could have 500 different maintenance of membership windows. And basically what that contract says is that maintenance of membership clause basically says you can only get out of this union within a 15-day window prior to the ending of that contract. So if a contract goes 4 years, you basically have a 15-day window prior to the end of that contract. That's the only time that you can get out. And if you miss that window, sorry about your luck. You're locked in for the next contract.
Does the union have any kind of responsibility to communicate that, for example, your health, you can change and you have that window to opt in and opt out, but you get that notification that, hey, your time frame is here and you have to do that?
No, there is no notification of that. No.
Thank you.
Thank you, Representative Leanne Kruger-Branicki.
Thank you, Mr. Chairman, and thank you each for testifying here today. Mr. Williams, I'm curious about something you said in your testimony. How exactly were you contributing to the Democratic Party through your dues to the teachers union?
Based on contributions, when you look at the breakdown of where money has gone, I can speak to the 2015-16 election cycle. When you look at total government union political action committee contributions, of 6,224,580, 89% of that went directly to Democrats. 5,564,000.
And are you aware of the fact that unions have to solicit separate funds for political contributions, and they've always been prohibited from using dues or fair share fees for political contributions?
I am aware of that for the political action campaign, yes. However, when you look at anything outside of that, the argument that dues cannot be used for any sort of political statement, I would point you to the Americans or the AFT convention.
I'm sorry, which AFT is this? Is this the teachers union or your new organization?
We go by AFFT. So,
that's very close.
Yes, it is close. But AFT's convention, again, that conventions can use union dues. And at that convention, they had Elizabeth Warren, they had Bernie Sanders, they had Hillary Clinton speaking. At the NEA convention, they had David Hogg. Certainly these are very politicized public figures.
But again, you said that your contributions were directly going to the Democratic Party, which is and has always been illegal. Unions need to solicit other funds to do that. You said to my colleague that your organization is not encouraging members to leave their unions. I'm looking at your website right now, and there's a section that says, "My choice, my vote, 3 steps to resign from your public sector union." So can you tell me again, are you encouraging union members to disenroll from their union?
We are giving them the tools that they need to exercise their rights, yes.
So yes, you are.
We are giving them the tools they need to exercise their rights, yes.
And is your organization affiliated with the Koch brothers in any way?
No.
Are you
Or Betsy
associated
DeVos,
with
or,
the,
like, yeah,
what
I
about
mean,
the
we'll throw 'em all
Commonwealth
out there.
Foundation?
I'm sorry?
What about the Commonwealth Foundation?
No, we are our own separate 501c3.
Is the CEO of the Commonwealth Foundation not one of the 3 members of your board?
He's on the board, yes.
So you are associated with the Commonwealth Foundation.
To the extent that there is a member of our board who is involved in
Okay.
the Commonwealth Foundation.
And the Commonwealth Foundation also has ties to the Koch brothers as well. One last question for Ms. Mumford. You talk about grassroots volunteers. Are you actively encouraging union members to disenroll from their unions right now?
No.
Americans for Prosperity opened a new field office in my district about 2 weeks before the Janus decision came down in Delaware County. I drive by it because it's right down the street from my legislative office. Exactly what kind of grassroots activity is happening out of that field office?
So you are free to stop by at any point. Our field director has been working there for about a year. I think that office opened fairly recently, but he lives in Delaware County. That's where he's from. This week he had a fantasy football draft in his office for activists who were there. There are training activities going on, Grassroots Leadership Academy, phone banking, door knocking, all of that stuff happens out of that office, but you are more than happy to come by at any point.
They're welcome to stop by my office and see me too.
Sure, no, that sounds great.
And so the door knocking and the canvassing that's happening, are you targeting union members with that activity?
No, I mean, that's not a specific target. We talk to, it depends on we do issue advocacy, so it depends on the issue that we're working on. So if we're talking about taxes, we'll talk to citizens who we think care about taxes and spending. If we're talking about energy issues, we'll talk to citizens we think care about energy issues. Often we're just door to door trying to figure out what issues citizens care the most about.
Representative, do you have any questions on the bill or the issue rather than the organizations
Yes.
testifying?
Last question. Have any of your organizations filed Freedom of Information requests to identify union members in Pennsylvania?
We have.
I have not.
I believe we have for the purposes of some of our cases, yes.
Okay. Thank you, Mr. Chairman.
Thank you. Representative McNeil.
Thank you, Mr. Chairman. This comment or question is directed to Ms. Mumford. When you mentioned West Virginia being one of the states that passed their own public sector laws, I decided to Google, and according to Google, the West Virginia is the lowest paid teacher average rate in the state, and Pennsylvania is the 9th highest. West Virginia is 45 and change, and Pennsylvania is 63 and change. My guess is that we're better off having Janus not in the public sector. I think our wages will not be able to be sustained, and we'll have teachers making much less money.
Well, the Supreme Court's already ruled on Janus.
I
so
realize that.
we
I'm just
can't
saying
make that
it's going to
decision.
hurt us here in Pennsylvania if we add our own laws to it.
Well, our interest is giving individuals the opportunity to be free to make their own choices. Significantly, just understanding what their rights are, as we talked about earlier, is important given the Janus ruling. So that's what we are here to support Representative Klunk's bill.
I know I support any teacher making a higher wage, and Pennsylvania pays pretty decently to support a family. Thank you, Chairman.
Thank you. Representative Cephas.
Thank you, Chairman. And so I have a couple of questions. So each of you discussed that you represent a particular constituency that you're advocating for. Can you give me the demographic breakdown of each of the constituencies that you are referencing during this hearing? Like, what is their gender? What's their race? What's their What's their average income for the people that you're representing?
So let me tell you about home care workers. We represent a home care worker and the man for whom he cares. In a case that was decided just recently by the Pennsylvania Supreme Court. Home care workers make on average $20,000 a year. The union that was enabled by the executive order wanted to take a 2% cut out of everybody's paycheck. 2% cut out of a $20,000 a year salary. It adds up for the union to quite a lot of money. There are 20,000 home care workers across Pennsylvania. We're talking $8 million for the unions involved.
And last question for the other two. We're constantly referencing the issue around political contributions and then pushing political candidates. What other issues have your clients raised that have been a concern with the unions outside of political contributions?
So nearly everything that we do has happened to involve work outside of the political contribution area. There was one case that we filed involving Pennsylvania law. It's been in place since 1970 that prohibits unions from using dues dollars to contribute to a candidate directly or indirectly, or to a party or to a political organization. However, unions have been doing that as well. So
I'm asking, outside of the political contribution argument, what are the other reasons that your constituency brings up as to why they want to be out of the unions outside of political contributions?
I can speak to that for a few people that I've actually spoken with in the last 2 weeks. Issues with representation. I have a situation where we have a client who he's a member of AFSCME in a school, and doesn't feel like AFSCME has any business being in a school, doesn't feel like he's well represented there, that they understand the needs of him in a school, and wants to get out. So it's not necessarily, I would say, speaking for the people that I've spoken to, it's very across the board. But I think if I were going to say the majority, it would probably be political activity. Is there?
So they're not talking about the collective bargaining. They're not talking about the pay raises.
No.
They're talking about the political contributions that are indeed illegal for.
But Representative Stevens, I do think you have to understand what Janice said. Mm-hmm. Janice was not about those sort of overt political activities that we've all recognized in the past. What Janice said was that it's all political, top to bottom. When a union goes and bargains over collective bargaining, benefits, salary, there are inherent trade-offs. So a school district, for instance, that ends up agreeing to whatever it is that the union wants, and I'm not taking a side on any of those issues, but there have to be trade-offs. If it's not a benefit, it's a curriculum or it's computers for kids. I mean, these are all inherently political matters. The point of Janice and what the U.S. Supreme Court held was that an individual shouldn't be compelled to support that, regardless of where they fall on the political spectrum.
Okay, thank you.
Thank you. Representative Klunk.
Thank you, Mr. Chairman, and I would actually like to get back on topic to the bill and the Janus decision. The Janus decision talked about this affirmative consent when it comes to paying these fair share fees. Since introducing this legislation, it has come to my attention that a number of employees who are non-union have been approached by members of the union to sign different contracts and pledge a certain amount of money to the union. I think in anticipation of Janus, maybe the unions saw the writing on the wall, anticipated it, and tried to get those employees on the hook prior to the Janus decision. So my question is more of a legal question. If you can give us any insight into what do you see happening with those particular contracts that may have been signed prior to the Janus decision, and how does Janus play into that for affirmative consent if those individuals now see the Janus ruling and really don't want to contribute anymore because they know that they actually have these rights under Janus, it needs to be, affirmatively made on their behalf that it's not a condition of employment. What do you see happening with those contracts that were signed prior to Janus?
Yeah, so it's true. Prior to Janus, there were a number of different contracts that started to pop up. Contracts that asked people to become a member of the union and to agree to pay that union a particular amount regardless of their membership status. So even if someone was to become a non-member at some point in the life of, the agreement usually pertains to a particular period of time, they would still have to pay union dues even though they're a non-member. To my knowledge, courts haven't addressed basically the constitutionality of a provision like that because, they're new. But I know there are a number of cases in the works to decide that question.
All right. Thank you very much for your testimony today, for being here. And we are going to move on to the next panel. We are actually surprisingly ahead of schedule, even though we went off into the weeds many times. If you want to hang around longer, Representative Nielsen. So now we have our next panel joining us, and first we have Steve Catanese from SEIU Local 668, Stuart Nade from the Pennsylvania School Boards Association, and Jim Vaughn from the Pennsylvania State Education Association. And I'd like to remind the panelists to please summarize your remarks to 5 minutes, and Shannon will be there to give you the sign when it's time, and then we can move on to questions after you have completed. So welcome, and you can go in the order that you were called: Steve, Stuart, and then Jim at the end. Thank you.
I thought we might draw straws. All right. Good afternoon, everyone. Thank you, Chairman Kaufman, Chairman Galloway, General Body, brothers and sisters in the audience and on the body. My name is Steve Catanese. I'm the president of SEIU Local 668. We're a union that represents 19,000 workers, primarily in social services. I myself am a member of my own local. I come from being a caseworker myself. Recently was a caseworker in a county assistance office. Happy to have the opportunity to testify here today. So as Representative Klunk's co-sponsorship memo notes, this bill is designed to ensure public employee union compliance with the Supreme Court of the United States decision in Janus v. AFSCME, which held that unions that represent public sector employees, such as our local, could no longer negotiate fee arrangements with employers for representational services to non-members of bargaining units. It is therefore remarkable that the Supreme Court, whose current composition has been described by many pundits as pro-corporate, has codified into law that certain individuals receive services from private organizations completely free of charge. However, while the outcome baffled us, while it continues to baffle us, the decision is law. It's a law by which we have abided and will continue to abide. Prior to the decision being announced, we sent letters to the employers that we bargain with on a daily basis, telling them that in the event of an adverse decision in the Janus case, they should stop collecting fair share fees immediately. Following the decision, we sent an additional letter advising them to cease collecting fair share fees, which brings us to HB 2571. We have long complied with our obligation to ensure that non-members only paid their fair portion for representational services. If there were widespread violations of this law before June of 2018, then the state legislature could have enacted measures to ensure compliance. The Pennsylvania state legislature has not, because such evidence does not exist. There is no need to ensure that public employee unions comply with the decision, and consequently no need for this bill, as there's no evidence that we've never complied with the previous law. The onus, though, to comply with the decision and this legislation falls as much, if not more so, on employers than on unions. It's remarkable that, with the exception of Ms. Nade from the Public School Boards Association, who is now not with us today, but that those who would bear the lion's share of the responsibility for implementation of House Bill 2571, including public colleges, county employers, and nonprofits, are not here given the opportunity to testify today. There are a number of contradictions inherent in the bill itself as well. Section 402A of Act 195, the Public Employee Relations Act, would be amended under this. This would mandate the employer would repeatedly notify, even before the start date for employees, that they do not have to join a union. This would constitute an unfair labor practice under the Act in Article 7, Section 1201A. Repeated notification of to an employee by an employer 26 times a year that they do not have to join a union is the very definition of coercive activity and flies in the face of established law. Moreover, such notification undermines the very principle of freedom of association upon which Mark Janus hinged his arguments. If I, as a future public employee, am told that I do not have to join a union repeatedly from my employer, who is in a position of authority over me, then a coercive effect of that notification impairs my ability to associate with a union freely of my choice. If I presume, rightly or wrongly, that ignoring the repeated notification of my employer about not joining a union will lead to disparate treatment, discipline, or otherwise retaliatory actions from the employer, then the law constitutes an impairment of my constitutional right of free association. As a union, we invite employees to join us freely of their own will. To do so, we have negotiated orientations in some contracts. This is not standard, but it does exist. These same contracts include clear procedures for how an individual may join or disenroll from the union. Attendance at such orientations are completely voluntary. Despite what was stated earlier, we are not, sadly, given the opportunity to sit with someone when they get hired on day one and make them join the union. We do sometimes get a moment in some workplaces to speak to people about what the union's about and how they can join. This bill would create a law that would statutorily force an employer to intimidate employees into not joining a union. How will this not impair individuals' First Amendment rights? Such actions beg the question, what are the priorities of this body? Why is this much attention, time, and taxpayer resource being paid to enact a bill that would create a new regulation on employers clearly intended to discourage employees from joining a union? Is similar time being invested in the regulation of bad employers who regularly seek to prevent hardworking taxpayers from exercising their legal right to organize a union? 30 seconds, I'm a long talker. Notification of union rights to all employees should be made out there, and I'll really rush through the rest of this. And the point I was going to make there is if we're going to notify some workers that they don't have to join a union, every worker, whether they're in a workplace that's organized or not, should be notified of their rights that they can, of their own free will, engage in concerted activity and join a union. Flatly, our union is predominantly female. Over 2/3 of our members are women. The collective bargaining agreements that we negotiate actually provide pay equity in the workplace. Pay equity in the workplace for public servants who earn less in the exercise of saving lives on a daily basis. Our members from 911 dispatchers, children and youth caseworkers, unemployment compensation officers who've testified in front of this board recently to help fix government that was broken by this assembly, they do that because they care about helping people. What this bill would do was impact those members, 2/3 again of which are female, and those workers who for the first time in their life have had equal pay at the workplace because we bargained it with the same pay scales that were disparaged earlier, they would lose that ability. What we're talking about is undermining that ability for people to actually bring bread home to their family for once, be the breadwinner that actually can come home from work and say, I have a union contract with benefits that save and help my family out. In closing, I got to catch up to where I was in my written remarks. We do believe that HB 2571 is unnecessary and unsound. It's driven ultimately by corporate special interests to erode the rights of hardworking, tax-paying Pennsylvanians. This will put costs on state government that would be passed on to taxpayers. This is not good government. I do appreciate you giving me the time and the ability to show some passion at this podium. Thank you all very much.
Good afternoon. I'm Stuart Nade, Senior Director of Legal Services for the Pennsylvania School Boards Association. Chairman Kaufman, Chairman Galloway, thank you for inviting us to testify here today. We are employers. The entities, the public school entities we represent in this big equation are the employers. Our individual members, elected school directors, thousands of elected school directors in their private lives, maybe employees, maybe business owners, maybe employers themselves. But when they sit on a school board, they are collectively employers. And one of their chief concerns is making sure that they comply with the law, that they don't violate employee rights, which gets a little more complicated in the public sector. And the issues that Janice confronted are issues that really only arise in the public sector. We're talking about employee First Amendment rights and the involvement of government in the form of the government employer agreeing to things that have an impact on employee expressive and associational First Amendment rights. So Janice is a big deal, but it was not a surprise. As you can see in our written testimony, the writing began to appear on the wall a number of years ago. So as I think our first witness, I'm sorry, I didn't catch the last name, but indicated, both the employers and the unions that we work with were very proactive. We sort of saw it coming. The result was not much of a surprise, I think, to most of us, and we did a lot of proactive measures to make sure that on the day that the decision was issued, that any collection of fair share fees stopped immediately, and months and months in advance, we put out information to say to employers, here's how you should prepare to do that so that it isn't a mad scramble for you. This is something you can just simply execute once you get confirmation, and was also important, once the Janus decision was issued, even though it didn't address Pennsylvania law, so it had to be analyzed to make sure that it had the same impact on Pennsylvania law that it had on the Illinois law that it was directly confronting. And it was crystal clear, at least to us at the School Boards Association, that the Pennsylvania law was equally infirm under Janus, and we could no longer be implemented. And so that sort of brings us to the topic of the bill, which is, I think some have referred to it as sort of cleaning up. We think it's generally not a good idea to leave laws on the books that can't be implemented constitutionally. So repealing them is appropriate. It's a good idea. The bill does that. It's also not a bad idea to tell employees what their rights are. We're kind of used to that. As employers, we have big bulletin boards in the workplace that notify employees of all kinds of different rights that they have under state and federal laws and that are important to them. How many employees actually read those bulletin boards? It's difficult to say, just like how many employees actually look at their pay stubs. It's also difficult to say. Nonetheless, we take steps to notify employees of their rights in a number of different contexts, and it's hard to say that that's ever a bad idea to tell employees what their rights are. The real question is how do you do so in a cost-effective and administratively efficient way? We generally think that the goals of the bill are appropriate, and we'll be happy to have further conversations about whether or not we can make the actual mechanisms as cost-effective as we can.
Thank you. And just a note, we did invite the Pennsylvania State Association of Township Supervisors as well as the Pennsylvania State Association of Boroughs to testify as well, and they declined. And with that, we can only assume that they didn't have great issues with the legislation either. So, as employers, public employers. So, and you may proceed, Mr. Vaughn.
Thank you. Good afternoon, Chairman Kaufman, Chairman Galloway, and members of the committee. I'm Jim Vaughn. I'm the Executive Director of the Pennsylvania State Education Association. I'd like to thank you on behalf of PSEA for inviting us to participate in this discussion surrounding House Bill 2571, which was introduced in the aftermath of the Janus v. AFSCME ruling recently handed down by the Supreme Court. For context, PSEA has slightly more than 181,000 dues-paying members. Of those, 142,000 approximately are active school employees, including teachers and education support professionals. Prior to June 27th of this year, PSEA also received fair share fees from an additional 6,800 fee payers. I'm estimating those figures. Now, we were certainly disappointed in the 5-4 ruling that overturned a decades-old precedent, and we don't agree with the rationale that the ruling was based on. Nevertheless, the United States Supreme Court has ruled, and PSEA is acting in compliance with the decision. PSEA and our local associations clearly understand that fair share provisions in public sector collective bargaining agreements are now unconstitutional. And to this end, we've done everything to fully comply with the court's decision. In the interest of time, I've detailed our actions in my written testimony and attached copies of correspondence to school employers and non-member employees following the court's decision. And in sum, I can assure you that we have notified all former fee payers of the ruling, and we are no longer collecting fair share fees from those individuals. Within hours of the ruling, PSEA reached out to contact school employers via email, mail, and phone and directed them to immediately cease payroll deductions for fair share fees. Today, we continue to partner with employers to obtain the information necessary to refund any fees where employers were unable to modify a scheduled payroll. We established a restricted account to ensure that any non-member fee payers are refunded expeditiously and with interest. Now, I'd like to turn my attention to House Bill 2571, and it's my hope to be clear and succinct on this point. We believe the notice requirements contained in House Bill 2571 are both unnecessary and may expose parties to unfair labor practices. As has been pointed out, post-Janus, public employers are prohibited from deducting fair share fees from non-consenting non-members, which makes the proposed mandate superfluous. PSEA has already provided this notice to non-members who were formerly fee payers. It seems illogical to require notice to non-members that they are no longer required to have any dealings with the union when, because of Janus, they are no longer required to have any dealings with the union. It should also be noted that the bill is silent with regard to the means by which the notification must be delivered, which creates the potential for abuse and exposes parties to potential unfair labor practices, discrimination in hiring, and interference with employee rights under PARA. And even if employers do provide the notification in a fair manner, as has been mentioned before, the legislation ensures anti-union bias by only explaining one side of the choice. In Pennsylvania, employees and their colleagues can determine for themselves whether or not to join a union. Individual employees always have the free choice to engage in or refrain from union activities, and if the stated intent of the bill is truly to ensure that non-members are aware of their rights following the Janus decision, the bill should require notice of their full rights. Instead of exclusively focusing on telling public employees of their right to not join a union, it should include notice of their rights to join a union as well, just as the overwhelming majority of school district bargaining unit employees have chosen to do in this state. In fact, PSEA could entertain supporting this legislation if it simply provides for an access to the full range of information to employees of their rights. Again, if the intent is to mandate notice to non-members every pay period of their right not to join a union, we believe it only makes sense to provide notification informing them of their rights to join a union as well. We believe it would be a disservice to public school employees to deliberately exclude union rights and benefits from proposed notice requirements, especially since we believe it's been proven that a strong union is in the best interest of employees, students, and their schools. I and PSEA am proud of the benefits and services we provide to our members. Our members are too. In the months leading up to the Janus ruling, local associations engaged in tens of thousands of conversations with non-members, new employees, and existing members. And we are encouraged and invigorated by those conversations. Overwhelmingly, these discussions showed that public school employees value PSEA and have made clear the value of our union is not simply bargaining and enforcing a contract, but also the heart of our membership is a resounding desire to be supported and recognized for the challenging and important work that our members do on behalf of Pennsylvania's students and schools every day. We will continue to provide the tools, protections, and resources our members need to perform their work because we know that they are constantly striving to improve their practice and to grow professionally because all our members are committed to making sure students receive a high-quality education. Thank you for your time, and I look forward to answering any questions you may have.
Thank you, gentlemen. I appreciate it. And I was notified that although I didn't have her on a list, I was notified that I missed Representative Donatucci last round. So we're going to start with Representative Donatucci.
Thank you, Mr. Chairman. This question is for Steve Cantonese and James Vaughn. Your testimony mentions your local associations have reached out to non-members. What is the typical response from these non-members?
I'm sure I don't mind going first. I mean, as having been a workplace steward myself before being in this role, it's not much different than the usual. We reach out to workers, explain the benefits of a joining union, why they should. They don't have to. Sometimes people do. In the wake of the Janus decision, remarkably, a lot more people who were previously fee payers joined because they felt in some sense they were paying a fair share. They didn't want to be a free rider, so we've actually seen a very strong response in the wake of it.
I can't speak to specifics of individual conversations because I don't have those. What I can tell you, though, is we have had hundreds of either former non-members or former fee payers have chosen to join the union, either prior to or in the wake of Janus. And we simply view this as a way to actively engage members in the union or non-members in the union, explain the potential benefits of joining, and to answer any questions or concerns they may have, and try to engage them in the union and make them active participants.
Okay, so is it your belief that public employers in Pennsylvania are already complying with the Janus decision?
I can speak from PSEA's experience. We've worked very closely with public employers in the employers that had fair share provisions in their contracts, and we believe we are doing a very good job of complying with the court case at this point and stopping the deduction of fees, and in our case, where it's necessary, refunding certain amounts of fair share fees.
Okay. And lastly, are unions required by law to represent non-union members?
Yes. In a bargaining unit, yes.
Okay, thank you.
All right, moving on, Representative Keller.
Thank you, Mr. Chairman, and thank you, gentlemen, for your testimony. I want to focus on a couple things that were brought out. Mr. Catanese and Mr. Vaughn, you had mentioned increased activity in people wanting to join the union in the wake or in the upcoming prior to the Janus decision. Are you aware of any collective bargaining agreements that actually went around seeking people to sign papers that might be fair share people that might not be union members? Did your collective bargaining agreements do that, or agencies do that?
So I think this echoes back to a point that was attempted to be made earlier. What do you mean in terms of collecting of a bargaining agreements, having people sign papers?
In other words, a collective bargaining unit going around and saying, "Hey, there's this Supreme Court decision out here. You better join, or we're gonna, you're gonna lose rights." So,
if you're asking if union members went around and talked to their coworkers and said,
"No, union officials elected like the." I'm just wondering if you're locals, if you're shop stewards, if you're people that represent the union went around to people and tried to get them to sign on to the union membership.
Our shop stewards ask members and or non-members to sign up every day. Yes, okay. That's a regular course of action.
And there was no increased activity around the Janus case?
Was there increase? Yeah. We went around, asked people. Okay. If you're not a member, is a really good reason to sign up, and most people saw why.
Okay. The reason I ask it, and I'm going to go back to you, Mr. Catanese, you talked about getting a notice every 2 weeks that you didn't have to join. You thought that was a little bit overbearing. That's what you said earlier, correct? That's harassment, I think is the way you said it earlier.
So and I want to go back to something Representative Klunk said when she introduced the bill earlier, that this would actually require unions to notify people of this. And this came up in an op-ed the Commonwealth Foundation.
But no, I want to, excuse me, Mr. Chairman, can we stick to the...
This is public employer notification.
No,
so the difference between a worker talking to a coworker and an employer repeatedly sending notification out is different.
And a union president. Because I'm going to give you an example. You said that getting notice every 2 weeks would be considered harassing or a violation of someone's rights because you're continually hounding them. I know of a person coming up to this. It was actually an AFSCME collective bargaining unit. One employee over 3 weeks was visited 6 times with a paper put under her nose saying, "You need to sign this." The last time, two people. So I guess the point I want to make is that you're making this sound like people just went and did this of their own free will, when I know, in fact, that people were coerced into signing this. You're the only one that didn't sign it. You're the only one that didn't sign it. So I guess I just want the committee to know that while this all sounds like an attack on organized labor, it's not. It's just simply letting everybody know what their rights are, because they are continually getting bombarded from the other side I'm going to get off of that for right now. The question I guess I would have to Mr. Vaughn, how do you measure teacher performance?
How do we measure?
Oh, excuse me. I'm sorry. I'm School Boards Association. Mr. Nade, I'm sorry. How do you measure teacher performance?
Well, we have a mandatory evaluation system that we're required to use in terms of annual evaluations for professional employees.
Okay. So you care more about how well they're teaching the students. That's really the goal of a public school employee.
Ultimately, that's our most important priority, yes.
Right. So if I'm a public school employee and it's been decided that if I have this much experience and this much education, this is what I make, what's my incentive to want to try and do better if everybody's getting paid the same no matter how I perform?
I think you ask a valid question that comes up in the context of labor relations in any context.
Okay, because I've heard from the committee that it's all about pay, and we want people to earn a good living, but we also want to make sure that our students are learning, the people that are providing services for the Commonwealth are getting the best service they can get. And when everybody is paid the same, no matter what, you don't always get just because you paid more doesn't mean you got better.
Can we stay on the bill, please? This really has nothing to do with the bill.
We were on lots of rabbit trails last time, if you remember, and most of them were yours.
Well, I guess I just want to make the point that people should earn a good living, but the point is being in a collective bargaining unit doesn't guarantee you that. What guarantees it is performance. And I just want to make the other point, since it was brought out in testimony, that it would be harassing to let everybody know every 2 weeks what their rights would be. It's also harassing to have an employee get visited every 2.5 days for a period of 3 weeks to sign a paper. Thank you.
Representative Cephas.
Thank you. A couple of quick questions. I know the one gentleman mentioned the demographics of your union earlier in your testimony. Can the other two unions let us know what your demographics are? I mean, since he brought up the issue around pay equity, I had a hearing a couple of weeks that talked about the intersection between the Janus ruling and pay equity for women. So if you can mention that, that would be great.
Certainly, I can I can tell you off the top of my head that roughly 3/4 of our union members are female.
Mm-hmm.
Beyond that, I don't have the specific demographic, ethnic breakdowns off the top of my head, but I'd be happy to provide that to
Great.
the committee. I also, if I could, with regard to the prior line of questioning, I would also be happy to share a number of studies that indicate that unionized educators and well-paid educators
Perform better.
Have better performing schools and better performing students.
Great.
Representative Dush.
Thank you, Chairman. First of all, both to SEIU and the PSCA, I want to thank you for the proactive way you've notified and getting the letters out. I saw the letters, and I appreciate that. But I want to go into a few things here. In a previous, with the previous panel, Representative Cephas brought up about other issues. And Steve, you brought up about the recent issue, or the issue last session, the beginning of this session, and blamed the legislature for what was going on with the Secretary of Labor and the $400 million of taxpayers' money that was being wasted on the BENMOD, the Benefits Modification Program. The Secretary, the administration, is the one that terminated those employees. We gave $30 million to the Secretary, and she didn't hire them back. Your guys were demonstrating out here in the hallway until I stepped into the middle of it and started explaining it to them. For the remaining 2 or 3 weeks and the whole way through till we finished that legislation, your employees were up in my office because they weren't getting the scoop from you. That is one of the other issues. And since both of you guys,
we're getting way off. This is another issue in itself.
This is why.
This has nothing to do with the written testimony or the bill on hand right now. And I respectfully ask, because I've been working real patiently as hard too.
Or when he chastised the legislature for the problems in the unemployment compensation system, that's where it started.
This is not unemployment compensation. That's not what we're
I
here
know,
to talk
but he's
about
the one who
today.
brought it up, not us.
If I may,
if I can address his issue.
Yeah,
I can address your issue.
Yeah, I just want to stick to this, Chris. I'm trying to, because
I'm sticking actually to it. This Representative Cephas asked a specific question about what other issues are causing members of the unions to not want to be members.
And that was the other
And this
panel.
is one of them.
That was
And
the other
I'm
panel.
gonna-
That has nothing to do with it. You could have followed up with those other panel to say, did you ever hear about this? They wouldn't hear about this. I mean, we're on a whole separate panel, and you just have their testimony. Nothing in their testimony.
Steve's the one
Nothing.
who brought this up.
Is it?
Now, to the second point.
Well,
the second part of
if
this,
I
since
may,
both of you
may
guys...
I respond at
Sure.
least to that portion of it? I'd be happy to, because I recall the moment that you walked down the hall to find our members, because it was me that ended up talking with you for a little bit. And as you claimed, you tried to explain to them why things were going wrong. The key thing you weren't doing at the time was listening. I didn't blame any individual legislator, but I blamed the General Assembly, because it was the General Assembly that did not pass funding. And it was the effort of our members, who were here lobbying every day, to explain to every person in this General Assembly, especially in this body, the harm that was being done to Pennsylvanians. Every single day, no action was taken.
I
So
can
bristle
appreciate, I
very
can
strongly
appreciate that.
their
but
right
you
to organize
come
in
to
a
the committee
workplace.
that worked very hard to get things done. So I take offense with that, because I worked very hard to make sure you guys were back in your seats.
Absolutely.
And to again.
So
And
let's
you
move
said-
on. And if we want
all right.
strict behavior in this committee, we will stick to the issues. So move on, get to the questions. There will be no latitude, if that's the way the committee would like it.
All right, Mr. Chairman, what I'd like to address is the reasons, as it was brought up, why members should be aware of their rights not to. And the question was raised, what other issues? Since both of you guys have members who are working in the Pennsylvania Department of Corrections, where have you guys been while people's lives have been on the line? It was me that organized family members and retirees not using active members simply because I want to protect their jobs. You guys get paid for this kind of activism. Where were you? We've got your people, the people you represent, getting sick from K2, fentanyl, carfentanil, and you guys have been silent. This is why your members want to
Chris,
get
can
out.
we
It's
move
not
on?
just...
Can we move on, Chris? Do you have a
Thank you.
question for the...
I want to know where
Testify.
you've been.
If I could, Mr. Chairman, I can't speak to the specifics of that right now. I'd be happy to bring our staff member in who works directly with that bargaining unit and have them discuss our actions with you.
But this is why. This is why your members want the latitude.
I
that
do
Mr.
remember myself
Keith-
directly being involved in a conversation last week to help make sure protective gear was being given to our members so they were healthy. We were also discussing how we could better talk with and notify more people and make sure that we know what's going on in the shops so we can advocate for what they need to be safe. If you'd like to know what we're doing, we'd be happy to tell you as well.
Well, there are a lot of your members who are asking me, where have you been?
Tell them, feel free to get in contact with us. We enjoy talking to our membership.
Representative Snyder.
Thank you, Mr. Chairman. I want to thank the testifiers for being here today, and I have a couple of questions for Steve and Jim. Outside of the bargaining contract negotiations you do, what other kind of benefits do your members get?
You sure you want to ask me?
I
It
do.
tends to get loud. No, so at least in terms of being members of the union, being a member gives you a say in every aspect of our process. We're a democratically run organization. Beyond that, we try to work with different organizations to provide member benefits for insurance rates, things like that, to kind of help folks out. We also give them legal advice as needed from time to time, depending on the situation, and really work to help enforce the collective bargaining agreement. But I think that's the other part of your question you didn't really want answered.
I'd agree
Jim?
with what Steve said, and some people think it might just be about liability insurance or free access to professional development. But what's really showing through, and I alluded to in my verbal comments, was the fact that our members really appreciate kind of a sense of community and shared values, and know that PSEA has their interests and the interests of public education at the forefront. And there's a real appreciation for that, and that we respect the jobs that they do and try to provide them the support they need.
Thank you. And I would just like to make some comments about what I've heard here today. I know my public school teachers very well, and I know how hard they work. And Representative Keller, your comments about what is their incentive if they are not being paid more, I can tell you firsthand that the public school teachers that I know, and I have 8 school districts in my district, not only are they dedicated, committed, knowing the budget constraints that we have in the state of Pennsylvania, they spend a lot of money out of their pockets to make sure that their students have what they need. I see it every day. My daughter is a kindergarten teacher, and I know the commitment she has. It doesn't matter what she gets paid. That commitment is the same every day. And all of her fellow teachers and the teachers that I know are the same way. Our school teachers spend more time with our kids every day than we do as parents. So I respect what they do. I would like to know from Jim and Steve how you felt when you heard Mr. Williams say you shouldn't even be here to testify today. How did that make you feel?
I believe we were invited here. We have a right to testify, and I'm happy and proud to do it on behalf of our membership.
Well, I would just like to point out also, you know, the 2-week notice by the employers, you want to compare it to your union steward asking you to sign a union card, not even in the same ballpark. That union steward doesn't have the ability to fire that employee or let that employee go. So I want to thank all of you. It's no secret how I feel about unions and the working people, and I will continue to feel that way and be a strong advocate. Thank you.
Representative Kruger-Branicki.
Thank you, Mr. Chairman. For Steve, and I want to ask a question to clarify something that was said in the previous panel. So for PSEA and SEIU, are member dues used for political contributions?
No.
A prohibition against direct contributions to candidates.
There's a prohibition against direct contributions to
Yes,
candidates.
and to that end, not to go down a rabbit hole, but fair share fees were created to, we are allowed to talk to our members about, we call it member-to-member advocacy about elections. In terms of the fair share fee, the costs of that were calculated and removed from the dues to arrive at a fair share fee figure. And we had that arbitrated from objectors for well over a decade, and arbitrators agreed that our fee was properly calculated each and every year. So for those quote-unquote internal member purposes, those were extracted from fair share fees. So those weren't going to support those efforts.
And just to echo that, I mean, we have a similar process we go through with similar auditing, filing, paperwork's done every year to make sure the fee is calculated, and it was readjusted every year to be reflective of the services we gave.
So fair share fees are not or never have been used for political contributions?
No.
Okay. And Jim, PSCA was really under the microscope on the last panel. Do you endorse Republicans as well as Democrats here in Pennsylvania?
Yes.
Actually, where I live, sometimes it's more Republicans than Democrats. So your political support is not just going to members of one political party. Okay. And the Janus decision at the end of June basically rolled back 40 years of precedent of precedent that supported the rights of workers to unionize. And I want to point out that this bill goes even further than that Janus decision. Payroll deductions from consenting non-members were not actually struck down by the Supreme Court, but this bill, House Bill 2571, would go even further and prohibit public employees from using payroll deductions for consenting non-members, even if they wish to make a payment to the union. Now, Representative Klunk mentioned in her opening remarks that there's 28,000 members who pay fair share fees in Pennsylvania. So if this bill were to pass and we were no longer able to use payroll deductions, what would the cost of that be and what would the impact be?
Go ahead first.
That's hard to ascertain because we don't I can't tell you how many of those non-members or former fee payers would choose to join and pay. So it's hard to put a concrete figure on that. We could try to calculate it, but I can't sit here today and estimate what that would be.
Yeah, basically similar answer on that as well.
And what would the mechanism be for those non-members who want to voluntarily make a contribution? If there was no payroll deduction, how would that payment actually get made?
It depends upon what local they're in within PSEA. We have direct dues set up within a small amount of our locals right now. Most likely they could write a check.
And yeah, for us, it would have to be a myriad of systems, whether it's writing a check to direct pay system. I mean, simply just like any employer, we try to go for the simplest route. If someone freely chooses to be a member, we go for the simplest way for them to pay dues. If they choose to not be a member, their dues deduction stops. So for us, it generally ends up being payroll. If it was not payroll, it just makes a situation that is intended to cause creative havoc.
Okay, thank you.
Representative Nielsen.
In good spirit, Mr. Chairman, I will try and stay on subject and point. Thank you, gentlemen, for your testimony today. I don't have a whole lot of stuff. I appreciate your testimony. You talked about notification. You brought that up and who's going to pay for it, how's it going to happen. And you talked about the signs. Do you think it's right that the legislator mandates all employers to notify, instead of doing signs, notify them for every little safety, every little OSHA sign that we mandate? We mandate child labor laws, all that stuff. Why you agree with this legislation and you say, yeah, we should notify them of these rights. Do you think we should mandate all Pennsylvania employers to mandate for all those signs in the back of your facility?
Well, Representative,
because we should do that every 2 weeks like this, right? Or every week or whatever.
I think what I said was more along the lines of it's hard to argue that it's a bad idea to tell employees what their rights are. How that's done is another question. I can tell you that if you look at those, and they're fortunately to make it easier for employers, the Departments of Labor and Industry at the state and federal level will sell you these posters that have everything that supposedly is mandated by law in terms of notifications.
For one low price of like $1,000 annually.
Fortunately, it's not quite that much, but there is a cost to it. Any kind of notification has a cost to it. Mm-hmm. And I think it's helpful to understand we deal with notifications with students too and their families and annual notifications and the boilerplate. Have you looked at a school calendar lately with all of the boilerplate in the back about all the annual notifications? So I think it's worth more conversation about how to accomplish the goals of the bill in a way that's efficient and actually works, actually gets the message across. As I alluded to before, you can put boilerplate in a pay stub, but that doesn't mean anybody's really going to read it every week, or every 2 weeks, I should say. It's also helpful, I think, to keep in mind that employers of any kind, public sector or private sector, they don't deduct anything from anybody's pay if the employee does not provide an authorization for the payroll deduction, unless it's one of the things like federal tax withholdings and Medicare and Social Security. So there are a number of things that are already at work, and it may be best to piggyback on those to actually ensure that when somebody provides that authorization, the employer is not going to make a deduction without. That might be probably a more efficient and effective way to provide the notice that the bill contemplates than a sort of an every 2 week boilerplate in the pay stub kind of thing. So I think that's worth a further conversation. It's certainly not something that I think anybody wants to try to nail down right now. But I thank you for your question.
Thank you, Chairman. That would be all for me tonight.
Thank you, Representative Nielsen. Representative Klunk.
Thank you, Mr. Chairman, and thank you to my colleagues for joining us today and our panelists as well. Just wanted to make a note that if I did misspeak earlier, I wanted to clarify that the bill does direct public sector employers to inform non-union members about the Janus decision. Just if I misspoke, I apologize. But I first want to thank you for our union folks who are here today for your proactive nature and the School Boards Association in making sure that your employees knew about the Janus decision, and we're proactive in informing all of those members and all of the districts all throughout the state. I really do appreciate that. I wanted to touch on a couple different things. First, wanted to reiterate that this payroll deduction, taking that out is really important because we need to make sure that that employee affirmatively, based on that Janus decision, affirmatively decides to contribute, if you will, that fair share fee. So that there's no question of whether or not the individual might change their mind and might not be able to get, in there to say, hey, I don't want this, to be deducted this week. I'm actually going to change that. And then you have to refund their money, if it would be proactively upfront. Do you guys actually just question a PSEA? I'm assuming you have a mechanism on your. Do you have a mechanism on your website now to collect for political dues, where you can go in and give your credit card information and make a political contribution to PSEA?
For our
On your
political
website?
action committee?
Yes.
Yes.
So you could, if you're doing that now for your political action committee, you could have an employee who wants to provide fair share fee money or whatever. They could make that through your PSE website. So you have a mechanism to do that online, correct?
Right now, we have no plans to collect voluntary fees from individuals. We view non-members as potential members and would really prefer they join the PSEA and become an active member. We don't have plans to collect voluntary contributions from non-members.
But you could, based on the fact that you do have a mechanism on your website to collect other fees
in any number of ways. That's not how our business model is set up to account for who is a member and who is a non-member at the local level, because PACE is a separate legal entity. So we could set it up, but we are not set up for that.
Okay, but you could. There's a mechanism to do that. So I wanted to check with you on that. In your testimony, it's Jim. It's Jim, or you go by James? Jim. Okay. My brother's Jim, and he doesn't like me to call him James. It's James if he's in trouble. So, Jim.
It was for me too.
Good. So in your testimony, you talk about, and I know you had spoken about it too, making sure that if we're going to notify these non-union members about, their Janus rights with fair share fees, that you would prefer to also let essentially all employees know that they could join a union as well. So if we were to, talk further about this, would you be in support of the bill in concept if we would, potentially move forward to allow or to require the notification of Janus rights as well as the right to join a union?
I believe the current requirement is for non-members, and we're happy to talk about the legislation further after this hearing.
So you would be potentially on board if we would include all employees, not just members and non-members, including members of the union as well?
We've not given consideration of that, and I don't have the authority. We're a small D Democratic organization, and our legislative positions are taken from the ground up, so I cannot commit to that and would have to take that back to our membership.
But that is certainly something that, I know you testified on it, you would be willing to have further discussions on?
We're always willing to have discussions.
Thank you.
Thank you. Well, unless I missed someone on that list, wave your hand now if I did.
Second round.
You have to deal with your colleagues there. All right. Well, with that, we will adjourn this meeting of the House Labor and Industry Committee. Thank you for the spirited afternoon, and I'll see most members tomorrow morning at 9 a.m. sharp. Thank you.